I've seen quite a few videos just recently where people are talking about squatters and squatters' rights and somehow promoting the belief that entering a residential building as a trespasser, you somehow inherit squatters' rights to the property. But such people have probably not read Section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act of 2012, which creates, quite specifically, an offence of squatting in a residential building. In fact, the term squatters' rights has been hugely misunderstood, but make sure you watch till the end because I'm going to explain exactly what it does really mean. So welcome back, but if you're new to me, I'm a barrister who helps you understand law. So Section 144 of the Act provides as follows. A person commits an offence if the person is in a residential building as a trespasser, having entered it as a trespasser. B. The person knows or ought to know that he or she is a trespasser. And C. The person is living in the building or intends to live there for any period. Now, it is of course important to distinguish with subsection 2 that the offence is not committed by a person who is holding over at the end of a lease or a licence. So in other words, if a tenant overstays and even doesn't pay the rent, it doesn't make them a trespasser because they didn't enter it as a trespasser in the first place. This is speaking of people that deliberately enter a residential building without permission of the owner, thus is a trespasser by legal definition, and then intends to live in the residential building. The offence was introduced because of public concern about the harm that trespassers can cause. It was designed to protect owners and lawful occupiers of any type of residential building. And this of course includes both the homeowners and the tenants who may have been excluded from their homes by such trespassers. Now, some of you might have the question, what if you have a commercial premises which has a flat above it? Clearly, it's a split property with the flat above being a residential area of the property. Well, this is covered by subsection 3, which provides that a building includes any structure or part of a structure, including temporary or movable structures, so non-permanent buildings, and the building is residential if it's designed or adapted before the time of entry to be used as a place to live. Another question that arises is what if a trespasser has been in there for a period of time and then hands over the keys or otherwise relinquishes the property to yet another trespasser? Some of you may argue that the second trespasser has permission from the first trespasser to enter the property. However, Section 4 of the Act makes it clear that for the purposes of this offence, the fact that a person has derived title from a trespasser or permission from the trespasser to enter the property does not prevent them from being treated as a trespasser as against the owner or a proper lawful occupier for the purposes of this offence. Now, of course, this offence may have some overlap with other offences. For example, if somebody has broken a window or a door to enter the property in the first place, that would amount to criminal damage, and potentially theft and burglary are also involved. But the offence of squatting in a residential building itself, albeit treated summarily, does attract a prison sentence of up to 6 months and or a fine. So the term and the notion squatters' rights actually stems from Section 6 of the Criminal Law Act of 1977. Under that act and that section, it makes it an offence for anybody without lawful authority to use or to threaten violence to secure entry to any premises against the will of those inside, which of course would include trespassers. So you can't simply use or threaten violence against anyone inside in order to remove them, hence the term squatters' rights. This offence of using or threatening violence is committed by any person when it's used against somebody who is inside who is opposed to the entry, which can include someone who may themselves be a trespasser in the premises. However, and as always, there are some exceptions. So many of you might wonder, what if it's your property and you have been displaced and excluded from your own property by trespassers, and now you're worried about being threatened with an offence for threatening or using violence to remove them? Well, fear not, because the law has accounted for this eventuality as well. Section 6, subsection 1a provides that this offence of using or threatening unlawful violence does not apply if you are a displaced residential occupier or a protected intending occupier, which is a little bit more complicated, and such a person is even defined, however obvious it might sound, in sections 12 and 12a. Subsection 3 of section 12 provides that, subject Subject to subsection 4, which is below, any person who is occupying any premises as a residence immediately before being excluded from occupation by anyone who entered those premises or any access to those premises as a trespasser is a displaced residential occupier of the premises for the purposes of the Act, for so long as he continues to be excluded from occupation of the premises by the original trespasser or by any subsequent trespasser. So that includes the scenario where one trespasser might hand the keys to someone else and then the second person argues that they had the right to be there against the original occupier. This is covered by this section of the Act. Subsection 4 provides that a person who was himself occupying the premises in question as a trespasser immediately before being excluded from the occupation shall not, by virtue of subsection 3, be a displaced residential occupier. So there you can see it is set out quite clearly that a person who is a trespasser who may be even displaced themselves or they've had the keys and feel that they are being displaced by the original owner are not a displaced residential occupier for the purposes of this Act and for the purposes of this offence. So the bottom line is that this offence made it much more difficult for any trespasser to assert that they have any rights really in respect of residential buildings or their occupation thereof, and that their occupation of said building, if it's a residential building, as a trespasser will be a criminal act. The police will have specific powers of arrest under Section 17 of PACE, the Police and Criminal Evidence Act of 1984, to enter such a property to arrest a person who is suspected of squatting in a residential building. The police will not, or at least should not, therefore, be deterred by any such signs saying squatters' rights or any protests of squatters' rights by trespassers who are occupying the premises. And finally, many people may ask about the homeless. Local authorities have specific legal duties towards homeless people, and so if anyone is homeless or is threatened with homelessness, if they approach the local authority has a duty to assist them, and there may also be a duty to provide them with accommodation. So I hope this video has been somewhat educational, enlightening, entertaining perhaps, and to dispel some of the myths and the ideas that you might see, particularly on certain social platforms where you get lots of people asserting these things which are ultimately untrue. So if you do like my content, I'd really be really grateful if you hit that like button and subscribe, and more importantly, you share it with somebody, because I am getting ever closer to 250,000 subscribers. I am very grateful on my mission to 1 million. So thank you for watching.